today? Yes, my name is Jude Ugwai. I'm one of the lawyers to Nnamdi Onyendu. We normally call him Onyendu. He's our leader. We're in court today, and he has several applications, particularly the one insisting that his right to final written address, guaranteed under Section 294, subsection 1 of the Constitution, be allowed him, that even if the court insists on foreclosing his right to defend the matter, he has given evidence, and that is the position of the Supreme Court, that once you have cross-examined the prosecution witnesses, you are deemed to have given evidence, in which case you have the right to sum your evidence by way of final written address. Nnamdi now told the court that even if you are committed to determine the case without my defense, I want to file final written address on 2 grounds. During trial, your lordship said that any objection to the admissibility of the documents tendered before your lordship can only be agitated and addressed in the final written address. I've not done that. I want to do it in the final written address. Number 2, I did not waive my right to final written address. If the prosecution waived their own, that is peculiar to them. But insofar as I did not testify and I've rested my case on that of the prosecution, I should be allowed to tell the court the relevance of my cross-examination questions, the answers of the witnesses of the prosecution, and the effect on my freedom. But the court insisted that he would not listen to him, and in a haste dismissed all applications and then intended to proceed on judgment. And the man said, you cannot do this. That is not what the Lord says. You have not given me the law that allows you to deliver judgment without giving me my opportunity of addressing the court on my defense. And the court said no, and then proceeded to give judgment. In giving this judgment, the court convicted Nnamdi on the 7 count charges. But in convicting him on all the counts, the court failed to make a statement at least once on the validity and sufficiency of the discrediting of the witnesses of the prosecution. They were cross-examined by learned senior advocate of Nigeria, particularly Chief Kanu'S, a former attorney general of the Federation, Chief Onyechikpazo, a professor of law, a renowned jurist. But these questions, for instance, if I may give you an instance, they talked of importation of transmitter, and Onyechikpazo asked under cross-examination, did you get any document or evidence from the customs department to show that there was no lawful importation of it? And the person said no, and there was no such evidence. But the court proceeded to convict without in any manner evaluating the evidence of that cross-examination, without allowing him to file final written address. And that tells us how biased everything could be. But as lawyers, it is left for us to get the record of proceeding, study it, and go to the next level. However they want it, our law is that no matter the nature of the offense for which you are charged, you have the right to defend yourself and right to appeal against any conviction. They may look at it that he's unruly. He may be unruly, I may agree to that, but there are circumstances warranting his conduct. This is the man that was arrested in 2015. His prosecution started. The court granted him bail in 2017 in spite of objections. He was at his hometown. And he ran away for his life and physical well-being, going to a court for appeal. Court for appeal said, under the law, that you cannot arrest this man from Kenya and rendition him to Nigeria without due process of law. That renders the whole proceeding invalid. And they went to Supreme Court. And within the time they went to Supreme Court, out of time, from the time of conviction, the time of the decision of the court of appeal, to the time they went to the Supreme Court, this man was in detention, even when there was no law holding him. They further went to court and got an order for stay of execution. to ensure that Nnamdi is not released. I do not know of any law in Nigeria that allows a stay of execution applicable in civil matter to criminal proceedings. But that happened, and that is the peculiarity of our case. We went to the Supreme Court, challenged it, and the Supreme Court said, okay, let us first of all determine the validity of his arrest and detention. They now said the arrest and rendition to Nigeria, though illegal, that his remedy is a civil suit by way of fundamental right enforcement. But that it does not matter, he should still undergo his defense, his prosecution. But that whatever objection he has, he can raise it at the trial court. He has come to court, he is not a lawyer, and he said, even during pleading, arraignment, he said, I do not understand the charges for which I stand trial. If you explain the charges, I will defend myself. And then he went further to say, these laws are repealed. And of course, the court admitted the laws today. The trial court admitted that they were repealed. If you tell me the law under which I'm charged and the validity thereof, I will defend myself. Eventually, it was not told to him. He was meant to defend himself without knowing it. And he said, I don't do that. The court foreclosed it. Let us say the foreclosure is right. He has come to file a motion before the court that I have my right to defend myself. I have the right to file final address. Please allow me to file final address so that I articulate my point and you make your decision. The court refused and ordered that he should be removed, sent out of the court. That was what happened, and the court now gave the judgment with several appealable grounds. Our prayer is that the Federal Republic of Nigeria should not be emotional over this case. It is possible he's wrong, it is possible he's right. But either way, government should allow due process of law, look at the evidence. If there is appeal, look at the record of proceeding and know whether his right to fair hearing was denied him, and whether the proceeding was done in line with the law, and whether this trial complied with law. If, for instance, the law or the offense for which he is alleged to have violated overseas, which the publication is said to be overseas, is not shown to have been an offense in those countries, my brother, the little I know of law is that it will not stand, because the Attorney General of Relations shall have to show that the offenses for which he stands trial are also offenses in the foreign countries at which the publications were made. That is Nigerian law. It is in section 76, boldly written jurisdiction. If they say they don't bother about those ones, then we come to the issue of this repeal, that this man said this law has been repealed. The court today now said there are savings clauses. There are saving clauses, but the authorities that limited the scope of applicability of saving clauses, and that is why we, the convict now wanted the court to say this is the position of the law, but there's a saving clause, so that the court will be addressed on the validity or the strength of the saving clauses. So my brothers, people should not panic. It's a gloomy day, it's a bad day for us. We are almost mourning. Igbo land is mourning, but I assure you that in law or in literature we say we have reached the climax. There must be an intervention and we go to the Duma. God will save us and we will come out. If President Tinubu says that he will not interfere with due process of law, that is his right. That is the law. This is the time for him to interfere for whatever reason. He said he cannot interfere with due process of law. Today, the due process of law is completed. Whether we go on appeal or we don't go on appeal, this is the time for him to act, and act well for the benefit of Nigeria, for the peace of the country.